So I believe we're now live. This is the first in a series of webinars on high-value cross-border finance by my company, Offshore Alert. For those out there who don't know me, I'm David Marchant. I'm the founder, sole owner, and CEO of Offshore Alert. I've been a journalist all of my working career, so 36 years, and I specialize in exposing serious financial crime while it's in progress, particularly investment fraud schemes. Offshore Alert was launched in 1997 and provides information on high-value cross-border finance with an emphasis on high confidentiality jurisdictions, commonly known as offshore financial centers. My company has two revenue streams: subscriptions. We publish news and documents that are designed to alert subscribers to red flags in high-value cross-border finance. We've exposed over 170 investment frauds over the last 23 years. I've been sued many times as a result of that. Subscribers have 24/7 access to all of our news and documents from our website at offshorealert.com. We also have conferences. We've been holding annual conferences on financial intelligence and investigations in Miami, London, and Sao Paulo in Brazil. After holding 25 or so of these over many years, we postponed an event for the first time ever a few weeks ago as a result of COVID-19. We had a Miami conference that was actually due to start in 4 days' time. And the postponement of that event was the catalyst for us implementing this series of webinars. It's clear that we're all going to have to adapt to this new environment and change how we conduct business if we actually want to stay in business. You know, this is not the time for just lolling around watching Netflix movies. So instead of holding physical events, we're going to start holding virtual ones, at least until things return to something resembling normality, whatever that ends up being. This is simply another type of conduit for our core business, which is supplying credible and valuable information. We're just doing it in a different manner. Over the coming weeks, we'll be holding webinars on a variety of topics, including fraud detection, asset recovery, insolvencies, and litigation funding. We're basically open for anything on the subject of high-value cross-border finance. If anyone has any ideas or suggestions, you know, please send them to me. You know, I want this to be a platform to help industry practitioners communicate with each other, make it easier for everyone to do business, discuss products, services, and relevant issues, and frankly, foster a sense of community among the new work-from-home workforce. Please bear in mind that Offshore Alert is not DreamWorks, and I'm not Steven Spielberg. So there will be some technical glitches, it's inevitable, but all I can do is try my best. So this first webinar is entitled How Asset Recovery, Insolvency, and Fraud Litigation Practitioners Can Adapt and Thrive in this, you know, most dreadful environment that we're in. And the presenters are Ed Davis, who's a lawyer with Sequel Law in Miami, although I believe he's currently in upstate New York at the moment. Warren Gluck, who's a lawyer and a partner with Holland and Knight in New York. And Margot McGuinness, who's an insolvency practitioner with Grant Thornton. So I'll leave it to you guys. So Warren, you're the only person who I can see on screen other than me. So do you want to take it away?
Sure. For those listening, I think we've just lost Ed. We've been experiencing a few connectivity issues, but welcome. It's an honor and a privilege to be here. For those who are dialed in, if there's two toggles, one which says cameras, if anyone is dying to see close-ups of us, but more appropriately, there's a toggle with slides, and those will be the slides that we are using for today's talk, which is how to make our way in the new world. And it certainly is a new world. Margot, would you like to do a quick introduction while Ed is hopefully reconnecting? Well,
can you hear me?
Yes. Margot, if you are speaking, at least I can't hear you. Okay. I think that we are going to have this brief time where Margot and Ed are going to try to redial back in. I'm going to see if there's a presenter room conversation going on. But I think it's high time to get this started. For those that don't know me, my name is Warren Gluck. I'm a litigator in New York with the firm of Holland & Knight. I've been at Holland & Knight my whole career and have been doing spending most of my time in the world of asset recovery, cross-border insolvency, litigation, and fraud investigation. And today's presentation is really about the future. It's a temporary future. It's how to act and what we can expect in the next 12 and 24 months. We are using a 24-month paradigm. We believe, and we're going to go with what's on TV, that within around 24 months, there should be a vaccine. Until then, though, a lot will happen. The economy will get worse in many respects, and the effects of what is happening in the world will become more and more real to investors, creditors, and the like. For those of us who are in the service business, for those of us who are in this world of asset recovery, it's going to be a challenging time. It's a challenging time for law firms, for insolvency practitioners, for accounting firms, for investigators. That said, this is also a time of real opportunity. When we were thinking about how to present what's happening now, we were looking at a few comparisons. You got, late night hosts, news reports saying, I'm so bored. When are we going to get back out of the house? What are we going to do? At least until Margot and Ed dial back in, what we can say is at least the people on this panel, and maybe they're on this panel for a reason, have never been busier. At least in the last 7 weeks, I can't think back to a 15-minute period where I was thinking, oh boy, I have nothing to do. There's lots to do. And there's lots to do whether you're working on cases, still in court, or continuing with your investigation and marketing. So the way we thought about it was those little Roadrunner cartoons, the Coyote and the Roadrunner. And it was a running gag that the Coyote would be chasing down the Roadrunner, would get overexcited, and when the Roadrunner would run across a cliff into the air, Coyote would follow, and it was only when the Coyote looked down that gravity kicked in and he fell to the earth.
Here now.
Excellent. And it looks like Ed is back in the thing. So that's the big analogy here. We have run straight off a cliff as the world. We're in a brand new scenario, but it's probably, for those of us who are interested in continuing the momentum, we're probably going to get to the other side just fine. If you look down and try to imagine what if, that's when you get into trouble. And I think this is a perfect time. Ed, can you hear me now?
Sure, I can, and I hope you can hear me. I don't know what happened, but when David left, it looked like Margot and I both got knocked out. I'm back in. I haven't seen Margot come back in yet.
I'm back.
But let's start with this. We want to be very careful that the topic that we're talking about is not perceived as in any way disrespectful to the fact that we have over 2 million people minimum that have been diagnosed with this disease, with COVID-19, and that we've lost tens of thousands of people all over the world, over 26 or 7,000 or more. It keeps changing. Could have changed since I looked at the TV last in the United States. So we're not in any way taking away or denigrating that loss and all of that pain and suffering, but we are trying to look forward a little bit past that and to talk about how we think this is going to fundamentally change our practice area, asset recovery and cross-border insolvency, and how it's going to change the practice of law and the practice of insolvency in general, because I think this is a watershed moment. It's never going back to the way it was before. I've already seen things happening with clients that portend that we are going to have fundamental structural changes in the way that we practice and the way that we garner clients, the way that we interact with judges, the way that we interact with each other, in every way that we can, almost every way you can imagine. So some of that's painfully.
I'm sure that was going to be brilliant, at least on my screen. That has unfortunately dropped off again. Our apologies as we continue to work through the technology here. I think it's exacerbated by some heavy use. I'd also like to thank what looks like more than 300 people who are watching, and we'll try to keep it interesting for you. So the structural shift that Ed just mentioned, probably one of the bigger ones, is that there is, aside from the catastrophic human toll, which again, we're not trying to minimize in any way, there's going to be a real economic consequence to the global COVID-19 epidemic. What you're going to see is that, like other economic downturns, 2001, 2008, when the tide goes out, you see who's swimming naked. As people try to withdraw their funds from private equity groups, from various vehicles, and find that they are not there or not as liquid as promised, more frauds are going to be exposed. There's going to be more traditional insolvency. There's going to be more investigation. And there's going to be a lot of sensitivities. For
Warren, can you hear me now?
those who think hard about what the future looks like, we think there's a lot of opportunity, and there's also a lot of danger. So the question is, how are you going to navigate it, and who are you going to turn to? This group, at least as we understand it, are largely involved in the prosecution, management, litigation, acquisition, or financing of large-scale recoveries, whether those recoveries arise from pure insolvency, from fraud, from some combination of the two. And so one of the first major implications that this group sees for the asset recovery industry is that it is an industry based upon very big numbers. There are some law practices, there are some insolvency practices where the numbers are much smaller. But especially in the offshore world, especially in the world of this audience, we talk about claims in the billions. We talk about claims in the tens of billions or even higher. One implication that we see here is that the sole mechanism thus far to attempt to mitigate the economic harm seems to be some version of quantitative easing. And it's varying from country to country and jurisdiction to jurisdiction. But the bottom line seems to be that countries are providing national level bailouts across industry sectors and paying for it largely by printing money. If you are holding claims or debt or an investment that's denominated in, for example, US dollars, one of the first things you should be asking yourself is, well, what is that dollar-based or euro-based, yen-based claim, investment, litigation going to look like in 7 years if we start to have inflation of the type that is normally associated with an increase in the money supply. Upon looking at this, we've already sort of begun to wrench out, and if you've got $1 billion portfolio, there are already products being offered so that you can lessen and mitigate against the worst case scenario. This is going to cost everybody money no matter what. There's only downside here, but the question is whether you can mitigate against the worst case scenarios in relation to inflation. Buy contracts which try to split the baby so that you can preserve maximum value. The next items we were trying to assess is, how's this going to be different than other major economic and global events, wars, during downturns, depressions. And I know that there's actually going to be a panel within this series coming up in a few weeks on this, but this fit into our slide too. One of the biggest differences between this go-round, what's about to happen, and what happened in 2008, 2001, dating back into the 60s, as long as frauds have been around, is that this time, on day one, for those that are meritorious, for those victims, sets of claimants, funds, insurance companies, what have you, who have been defrauded, or where the corpus of the estate has been removed, there's no longer going to even be an initial look to say, oh, well, what contingency shops are out there? Oh, that only works in the United States. What are we going to do? Let's delay our claims. Now, we anticipate that for those good claims, the increasingly mature state of the litigation funding industry is going to make this a different ball of wax. It is going to allow for enforcements to happen more effectively and sooner on a global basis. There is going to be a marketplace for the cost of money, for the cost of enforcement. And we think that there should be a better outcome for victims, for stakeholders, whether they are creditors, shareholders, insurance companies, or the like. Because again, while you're giving away some, that was always the case. But at this point, money really shouldn't be an issue for recovery of just claims, continuing assets, and so forth. The next item that we have been discussing in some detail is how the powers of the state are going to change and have changed. We, in these series and in other offshore alert conferences and presentations, we have always shown and been geared to where and in what jurisdiction am I going to be able to get the best information? Where is a subpoena power broadest? Where is a Mareva most effective? Where is a Mareva available? This is what we used to call jurisdictional arbitrage, picking the set of regimes that are most useful in any given case. What we have seen just in the last 2 weeks, for example, in Hong Kong, is that we have two courts who, for the first time that we are aware of, and particularly so in the United States, have compelled respondents, so think in this case either defendants or witnesses with a connection to a particular defendant, and properly the subject of the court's jurisdiction and discovery or disclosure requests. These respondents being compelled to supply smartphone passwords so that relevant text, data, interactions can be utilized by practitioners. The question which we will ask ourselves as a society from a normative perspective, but for offshore alert and insolvency practitioners, the question is, well, how far is this going to go? What we're seeing now is an invasion of the government into the traditionally private spheres of life on a level that's never before been seen and on a global scale. When you consider what's going on, for example, in India and how they are managing the COVID crisis. What you see is that in the most affected regions where regulation of the personal conduct is most important to stop the spread, there is interdiction. And what interdiction means is government interference in normal life so as to accomplish a particular goal. In India, there are places where those who have been diagnosed with either the coronavirus or those who have come in contact with it have mandatory video check-ins every hour. What does that mean when we are investigating a fraud, litigating a fraud a year from now? What about 3 years from now? Yes, I don't hear Ed or Margot. We're still trying to work out some technical issues. Let me see if I can allow Margot to speak. I'm hopeful that she
Hi, Warren. Can you hear me?
provide some commentary.
I can hear you, Ed. So very, very bizarre.
Yeah, Margot, we can hear you.
Okay.
Ed, are you there?
It's Warren Kent.
Oh, so Warren, what are you seeing different immediately as a result of everything that's going on?
Okay. I'll ask someone from the audience if they wouldn't mind posting a chat if they can hear Margot or Ed. To Niels, who asked whether the presentation slides will be made available, the answer is yes. And at this point, I will try to continue. Oh, good. The answer is we can hear Margot. So what I'm going to try and do is dial in. And Margot, why don't you speak for a little while?
Sure,
while I try to dial in.
I'll pick up from in terms of what we're seeing internationally in response to COVID, and certainly to what everyone perceives to be the challenges facing businesses ahead. You're seeing really across a number of jurisdictions a lot of changes and amendments or temporary measures to help businesses. Certainly, Australia, they have relaxed their insolvent trading provisions for a period of 6 months. We're seeing in the UK that they have temporarily suspended their wrongful trading provisions. Czech Republic has done similar relaxation, suspension of directors' duty to file for insolvency. The Cayman Islands, obviously near and dear to my heart, they've gone through a fast-tracked consultation process with the industry and are proposing amendments to the companies law to allow companies to restructure under the supervision of a restructuring officer. So that's aimed at providing rescue provisions to allow a restructuring officer to be appointed to a company where a company is likely to be unable to pay its debts, or where it's looking to put forward a compromise to its creditors.
That's and I take it, Margot, that what is your view on whether there will be relief on a more global basis from continued debt payments as we continue into this crisis?
Sorry, Warren, could you just repeat the last part ahead of
my question is whether you could see a Switzerland-style law barring debt enforcement taking root in the offshore jurisdictions with which you come into contact with, or in U.S. or Canada?
I say, I mean, the Swiss style certainly is certainly more aggressive than what you're really seeing in some of the other jurisdictions in terms of staying any sort of enforcement proceeding. I'm not sure you'll see that sort of move in Cayman or other offshore jurisdictions. Certainly Singapore, they've done like others and provided temporary relief for non-performance obligations and some relief on the conduct of the AGMs and requiring personal attendance at board meetings and some of the other measures to allow companies to have a reprieve and not the threat of some of these proceedings. In the UK, they've delayed or temporarily suspended filings for official liquidation. We haven't done that in the Caribbean regions or certainly in Cayman, but it's clear though that the industry is doing its best to respond and to provide the relief in the areas where it's needed.
And Warren, it's Ed. I'm on audio now. If you can hear me,
I can hear perfectly.
Just to add to that. I mean, I think I agree with Margot. And one of the issues we wanted to focus on today was the issue of what kind of work are we going to see going forward after we get back to some form of normalcy. And it's obviously insolvency, which is a sad thing that we're going to see an uptick in insolvency, and a good chunk of asset recovery lawyers specialize in or have a good portion of their practice focused on insolvency. And I don't see that you're going to see laws like that other than on a temporary basis anywhere, mostly by some form of executive order, because ultimately you have knock-on effects from all of that. I mean, each bank, they're going to have to change all of the bank's reporting requirements, their capital requirements, all the other, what they're allowed to do with regard to classifying assets and classifying loans. We've already seen in Miami, the commercial real estate market is starting to get weak, and there are already a significant portion of people not paying their rents, which is going to prevent people from paying their mortgages on a commercial basis. So I don't think that's something to get us over the hump as a bridge, but I don't see it as anything that's going to be long term, or it can't be really long term, because at the end of the day, those debts, if not paid, have several layers of knock-on effect that go to the core of what we do. So two things are going to happen, I think. One is we're going to have a significant amount of insolvencies. They're going to have to work their way through the system. And what can we do? We can rely on what we saw in 2001 and what we saw in 2008 and the aftermath of both of those instances, whether it's 9/11 or the Great Recession. It took time for those to work through, and the market's just going to have to adapt to that. The second piece is that people are going to get desperate, independent of normal fraud. That is, when I say normal in quotes, where people decide they're going to commit a fraud and go ahead and commit it. You're going to have what I've referred to as midstream frauds, where people who started out in legitimate business and were playing by the rules until they became so desperate they had to do something. They had to deviate from the normal course in order to stay afloat. And so not everyone's going to do that, of course, but some are going to get desperate and do it. And you're going to have those types of frauds as well, which are in many ways easier to decode than folks who start out planning a fraud. Mm-hmm. But I think those are the two areas we should really be looking at. One is that we're going to see frauds be exposed that weren't exposed before, that were ongoing because money was plentiful and we were riding the wave and surfing the wave of an economic expansion for 11 years. And then on top of that, other than that, I should say, you're going to see a historic level of insolvencies. And obviously that's what the insolvency system is there for, at least in the United States, to allow a fresh start, to clear these things through and allow people to start over. But I think what we're going to need to see, from the asset recovery standpoint, is the insolvency regimes in those countries where it hasn't caught up with the rest of the world use this as an opportunity to strengthen their insolvency regime. So if you've been traveling on an insolvency regime that's from the early 1900s, this is the perfect opportunity, excuse, whatever you want to call it, and necessity really, in order to get your business community back on its feet, to change and upgrade and update your law. So this is one of the things this group on this webinar should be thinking about, is how can we move our national insolvency systems, which are integral to asset recovery as well, to a more modern platform. Period. Go ahead.
Ed, and I think that's it's a really good point in terms of legislation, and I think what we've certainly seen in the offshore world, the courts have been very responsive to the new normal in terms of offering, video conferencing and hearing capability, and things are continuing to move, and they're being I think we can rely on them, as we always have, to really be able to as appropriate and under the laws, but use their discretion and their ability to be flexible and help parties work around some of these challenges in terms of getting evidence filed and allowing matters to move forward. And I think, Warren, that's been your experience certainly in New York courts as well.
It has. I things from my perspective, things have been extremely busy, and courts have gone out of their way to continue proceedings that can be continued, notwithstanding this conflict. And I think we're going to go through some slides in a minute on one point that Ed just made. I think one question we're going to have to ask ourselves is that how we're going to distinguish between asset flows and restructurings that are genuinely COVID related versus those that have the traditional fraudulent intent. And how are we going to be able to tell the difference between the two under circumstances where the COVID defense is going to be a real defense for the majority of persons who cannot pay debt, whose assets get devalued? It is real. If you own a restaurant right now, it's no fun. You're not getting any revenue. It's not your fault that the value of some investor who made an investment in that restaurant has gone away. So the question of how we're going to deal with what's clearly a monsoon of restructurings, asset transfers, and devaluations, I thought was an interesting issue. To Margot's point, we've seen a flood of both court activity and judicial decisions. So I can just speaking anecdotally, we've had no less than 4 or 5 oral arguments in the last 3 weeks that are serious oral arguments, 6 motions for summary judgment at a time. We've had evidentiary hearings. Those evidentiary hearings have been conducted by video. We've seen and taken video depositions. It's not ideal. You're getting your exhibits over to the other side beforehand, but they're working just fine. We anticipate taking around 20 to 30 video depositions in the next 180 days. So it's one every few days, and none of those proceedings are being held up really on account of this, aside from scheduling matters. We see, for those who know, one of Ed and I's favorite topics is intermediary bank discovery. For tracing assets, the banks are responding. They're responding a little more slowly, but I think even the act of responding has given those clerks and subpoena processes at the bank a sense of purpose, because life is going on. So we are continuing to both serve subpoenas, receive responses to subpoenas. We're seeing courts issuing decisions, in fact, issuing decisions at a greater rate. They probably have some time to write their opinions. We've seen 2 decisions in the last 3 weeks that I think are relevant for this group. One of those decisions is an important 1782 case in New York that was decided just 2 days ago. And in that case, the court has allowed the plaintiff, who's going to bring a foreign action arising from an Egyptian investment fraud, to access the DTCC. And for those who don't know what the DTCC is, it is the Depository Clearing Corporation. They are in charge of about $9 quadrillion worth of transactions principally involving debt and securities every year. And for the first time we are aware of, a court sitting in its capacity in 1782 has expressly allowed a litigant to issue discovery to the DTCC for use in an offshore related, asset recovery centered proceeding. In fact, one of the disputed issues in the world of 1782 discovery is whether 1782s are available for, quote, mere enforcement. And in this instance, the court has decided that the answer is yes. A few days ago, we saw. Oh, sorry, Ed, please.
Warren, no, let me just pick up on that point, because there's a lot, I think, of area that needs to be covered regarding how things are changing, and you just hit on a couple of them. So one area that we've always struggled with in the asset recovery and cross-border insolvency area is that we are almost always operating at an information deficit, and the people who either engaged in the cross-border improper activities or fraud, or engaged in even purely domestic fraud, they know what happened. They know exactly what happened, and they know what where the evidence is. But we are obviously in a dark room or with looking for the light switch, and we have to convince a judge to let us go into the dark room and to look for the light switch. And I think if we play this right, as a group, as a practice area, I think judges are going to open up and be more willing to allow us to engage in what some of our colleagues around the world refer to as a fishing expedition, because in some sense we have to go fishing, and there's just no other way around it. Now, there are obviously limitations on that, but this example you just gave of access to the DTCC is one example where I could see others coming to the fore, where the courts are going to allow access to information that looks and smells like it is for quote unquote enforcement, when in fact it's really to uncover the fraud. And one of the issues we always confront is, judge, they're trying to do discovery and aid of execution before they even have a judgment, and you shouldn't let them get away with that, when in fact it's relevant to a variety of issues in any fraud or asset tracing case, number one. Number two, the creation of evidence is an interesting issue, because if we have to act as lawyers in an environment where it is difficult to act because we can't have physical interactions, talking to people, having face-to-face depositions, the fraudsters are going to have to act in the same way. They're going to have to do video conferences. They're going to have to engage in more transactions that are over media that can be recorded. So there may be more evidence that exists of some of the statements that are being made that would otherwise not be available historically, because fraudsters are using their charisma to defraud people face to face. They may not be able to work as much face to face as before, so therefore they are going to have to adapt, and that could leave them exposed to leaving a trail that may not exist today. So I think there are some upsides down the road to this problem that we're facing, but the mechanics of how courts deal with it, putting aside the issue of jury trials and live evidentiary proceedings, which are more difficult. Obviously, jury trials are virtually impossible to do on a virtual basis, but doing evidentiary hearings, we already know people are doing them. You've done them, and other people in my firm have already done an evidentiary hearing by video. And we know their oral arguments are happening. We know around the world that's happening. We know that in Florida and in other states, they've now allowed court reporters to swear in witnesses on video depots remotely. It used to be that the court reporter had to be in face-to-face with the witness. So things are adapting, and I don't think that's ever going back. I don't think we're ever going to go back and roll back the calendar on those types of changes. So the idea of having to travel for example, a minor witness and spend a lot of money maybe go away, because we now are able to do it all by video. So I think there are some positive changes that we can take away from this unwanted crisis that can help us in the asset recovery world. I don't know if Margot wants to add to that.
Oh, I fully agree. And I think when you look, the question that I'm trying to examine is whether the imposition of the government into life that presently exists and that will continue to exist for the next 24 months sways the judiciary and in fact targets in a way that's more permanent. So are we going to see more if you if you can require an innocent person who's merely been exposed to the coronavirus to check in by video every hour, what is it that courts will be willing to do in connection with a convicted fraudster, or if in connection with a inquisition into whether a fraud has been committed? The boundaries are similar. And so what we're already seeing in Hong Kong is, at least novel to my knowledge, I don't know there was ever a realistic goal to seek a court order for an iPhone password before. And now there's a model for it, and I'm curious what will happen here. This slide, though, for those who, there's a few questions coming in. Yes, we'll provide the slides to anyone who would like them after this presentation. And then perhaps this is one for Margot. Is Cayman relaxing its views on using litigation funding to assist in access to justice?
Well, I'm not sure in terms of relaxing its use, but certainly Cayman has seen a number of cases go forward with litigation funding, and it's certainly, I think, as your point earlier, Warren and Ed, that puts us in a different position now than, say, where we were in 2008 or back in 2001 when we were seeing some frauds uncovered by the economic downturn, and there were certainly not the same level of access to funding as there is today. And I think certainly that's a positive, if there is positives in this to be considered for insolvency practitioners and lawyers alike, of having the ability to access funding and use it when you're tracing tracing assets and taking litigation offshore or onshore. But certainly, I think the Cayman courts are much more open to those arrangements. And it depends. It obviously depends on the case and what the arrangements are. I mean, there's still elements of the concern of it can't be tampered, but it's certainly a different world than it was 10 years ago.
I think to add to that, Warren and Margot, is that clients who historically would have self-financed their cases and not even thought about a litigation funder are now going to be more open to it because their treasuries have been depleted, just because of the nature of this particular catastrophe that we're facing. And everyone is hoarding cash and people aren't paying. And therefore, I think that as we come out of this, and as these frauds that we know are out there, that we believe are out there, that we know will be exposed by the receding tide, as they are exposed, these victims, whether they're even large corporate victims to the extent that they have the budget, are going to need access to litigation funding because they simply can't justify taking what little capital they have and putting it into, chasing down the assets, whether or not it's a good case or, in their mind or not. Even if it's the best case that's possible under the circumstances, they're going to have to keep their powder dry for their core business activities and not spend it on what are potentially deemed or viewed as an elective or something that they is in the want to have category rather than the gotta have category. So I think that litigation funding is going to play a bigger role for both of those reasons. And I would hope that governments who've been nervous about it in the past open their minds to allowing a greater access to justice through access to this money, which levels the playing field with the fraudsters.
I concur, and I mean, with limited experience in Cayman, we have seen litigation funding agreements being approved by the Cayman courts, so long as they're reasonable and they are protective of rights. In the United States, we've seen litigation funding agreements either be approved or being respected, particularly when it comes to discovery disputes. And I think there's a lot of sophistication now. As you said, I can tell from personal experience, we have a case now where it easily could have been funded by the estate, but the estate is almost using the litigation funding like an insurance policy whereby all activities associated with this particular litigation, which will be beneficial to the estate, are being covered by the litigation fund, and it's an actual 100% deal. And so
Right.
I think that there's some real value there.
Yeah.
Just to go to your point,
let me just add to that.
Okay.
Can I add one more point to that? The issue, I think the way this ultimately unfolded in 2001 after 9/11 was that you saw more access to information. So the 9/11 catastrophe opened up access to information because, rightly or wrongly, the United States government, whether they were being hypocrites about it or not, were adamant that more information was going to be available and that so-called secrecy havens were going to have to open up. So that was a watershed moment from the information standpoint. On the 2008 issue with regard to the Great Recession and the real estate fallout, that's when the funders really stepped to the fore in this area, because there was a lockup on capital, and there were great cases that were just sitting there, and there wasn't really a chance for these funders and the people who are investing in these funds to take their money other places for great returns. So they turned to this. So now we saw coming out of that crisis an expansion of litigation funding. And the real question is, what's going to come out of this crisis? And I think it's really more operations and perhaps the change in perception about how we can litigate these cases and investigate these cases, because the courts are going to have to, by nature, become more flexible and less rigid in the way that they apply rules and discovery rules and the like, because we simply can't act the way we did before in a pre-COVID world. So maybe the silver lining here, and obviously I'm not going to be silly and try to argue that going through this is worth it. It's not in any way, shape, or form, but it happened. So the question is, what's going to come out of it that would benefit the asset recovery practice? And to me, I think looking at it, stepping back as far as you can at the moment when we're in the middle of it, it's hard to be objective when you're in the middle of something. I think it really comes down to that might be the major change that comes out of this, that perceptions are changing on the other side of the bar, if you will, and the other side of the table, with the court allowing us more liberality and more flexibility in how we attack and investigate targets in these fraud cases. So I didn't mean to interrupt, Warren, but I thought that was a perfect place for that before we move on to the next topic.
No, I think it's important.
I just want to say, I think that's the right word for all of this in terms of just how uncertain everything we're facing, and that's right. I mean, none of us on this panel can say what's going to happen and how this is all going to develop, but we all know it won't be like anything we've seen before, and the flexibility that's going to require of professionals to navigate some very incredibly difficult circumstances with pretty nearly every variable you've ever relied on kind of moving and changing at the same time. It's what David said at the start. None of us can afford to be sitting around and wondering, creating very detailed plans. We're just going to have to be flexible and ready. And as you say, Ed, I think it's whether it's to Warren's point,
on the screen are some metrics that we've put together, and anyone who wants either the metrics or some of the underlying numbers can contact us. But what we're seeing are the initial reaction of courts. So most of the time what we're seeing are a lot of criminal trials being deferred. Jury trials are almost impossible. But the functions are generally continuing. Not always, but generally. It differs by jurisdiction, even within the United States. Differs state by state, court by court, whether you're in a trial court or an appellate court. Some states have even allowed or suspended the running of statutes of limitations. So there was a time, just for example, in New York, where filings were prohibited. And under circumstances where you can't file, you can't very well meet a statute of limitations. In New York, I think through the present, the statutes of limitations for various actions are suspended. Talk to your local counsel, make sure that you're up on it. But our due dates for briefs, due dates for motions and discovery are all being routinely extended. Here's some
I think the
information.
other-
I'm sorry.
Maureen, if I could just mention, as we go through these changes, that the courts are, these are short-term, I think, in the moment decisions that are they're literally making, week to week and month to month. The question is, where are the big change is going to come as to how the court systems adapt and adopt number one, but also adopt new procedures. And I think that that we might see some of our court systems grow closer together. We might see the convergence between the civil law system and the common law system that's already happening start to happen faster, because each of the courts are going to look to other courts to say, how are you dealing with this? What is the process that you're using to do this, to solve these problems? So I think it's good, and it's something that this group should try to foster, seeing what works in the common law system and better under these new scenarios, and what works better in the civil law system, and bringing them to the other courts, because the judges and the people who make the decisions about changing processes, and I think will, by definition, have to be more open to adopting other ideas. So I would like to see more involvement for victims in the U.S. style criminal system, which we don't have, but the civil law system has. And this is an excellent way that maybe we start to move forward. The other thing we need to consider is, what are the fraudsters doing now? What are the fraudsters seeing in this COVID environment and post-COVID environment that's coming that they can exploit and use to their advantage, because they're looking for the next weapon or the next series of weapons. And that's, I think, one of the topics that we'd like to get to in this, is that if I were a fraudster, what would I be doing? If I were a fraudster, would I be rubbing my hands with glee saying this is really good for me? And what we should be trying to game that and figure out what they're doing. And I don't pretend to have those answers, but other than mere guesswork, but that's something that we can come on to.
Well, I was trying to get us to the appropriate slide, and when we were at least discussing this and thinking about this, what we're talking about really is a 24-month plan. If one assumes that life will revert to normal, and I have every expectation that it will, people tend to revert to their most natural states. People like to be among people and go forward. What we're really talking about is a specialized 24-month plan. What to do in the time it takes to develop a vaccine, and knowing that it's temporary, knowing that what we're doing now is temporary. The question is, for this sort of title slide, how are we going to adapt and thrive? Are we going to take advantage of some of the gifts of time that have been given to us? Are we going to take advantage of new tools that come out of this? I mean, Margot and Ed, what are your thoughts on this concept that what we have is a window here, and what we should be planning for is how to deal with operating through that window, and obviously serving our clients and constituents the best.
Well, I think certainly it's going to depend on whether you're going to be dealing with at the outset of all of this frauds that are uncovered, or as Ed highlighted earlier, some of it will just be more operational distress in companies. So whether you're back into pure insolvency and preservation of asset positions, but I think either way you're going to be faced with having to be creative and probably making some pretty difficult choices as to what tools you can use and what's going to get you the best results. I do think you will see some opportunities to whether it is get more information or see a relaxing of certain kinds of conditions that may have stood in the way of certain avenues of recovery. And the challenge is going to be, can you be creative and see them on the spot and be able to react flexibly and quickly enough to use them?
Yeah, and I think just to add to Margot's point, one Look, as I said earlier, I think, there's the saying that never waste a crisis, and we've got a crisis whether we like it or not, and we obviously didn't want it, but we have it. So the question is, what do we as a group, as a practice area worldwide, what can we do? I think that politicians, as a general rule, in circumstances like this, don't want to look helpless. They want to look like they're doing something. They want to look like they're making changes that are going to make things better. And so you've got the dual impact of a public health crisis, which affects individuals, and you've got the economic crisis that's side by side with it. And I think if we could use this opportunity to upgrade our laws, to change things that are because we can say, this is legitimately say, I'm not suggesting we try to pull the wool over anyone's eyes, but that this is going to help businesses and help businesses, I guess, and other types of economic activity get back on its feet. That modernizing insolvency acts, to me, is an easy one. It's a layup, because we know that in certain countries that legislation has been sitting on people's desks, whether it's in draft form or it's already been approved by the legislature or equivalent of the legislature, and it's waiting to be promulgated, and it just hasn't happened. And so, to me, this is an opportunity for folks to go out and make those changes. Shame on us if we don't use. And I mean this in the most. I don't mean to sound like we're taking advantage. We didn't create the crisis to get this the opportunity, but shame on us if we don't use the opportunity to lower the barriers to getting information, to increasing the power and tools of insolvencies in those places where it needs to be changed or upgraded. If we can't have governments engage in dialogues to allow more multilateral exchange of information on a civil level, not between criminal authorities, but where we can have, for example, the Croatian version of 1782, and I'm picking Croatia out of the blue, but you know what I mean, the Brazilian equivalent of 1782. Why isn't that an opportunity? Why isn't this an opportunity to engage in that kind of backfilling? Because we've got the ability, I think, at this point to say, here's something you can be doing and be seen to be doing, and get judges involved as well. That's one takeaway I think we should try to get out of this, both this webinar and this crisis. Period. Full stop. I'll stop there because I know others may want to comment.
And I thought that was pretty good. And we have a few minutes left. I concur. I think we have to see every silver lining for what it is. I think, Ed, I think you were off the line when I was discussing this, but somebody in the audience just posed a question that I think is a core question for this group. And it's basically saying, look, if I was a fraudster, this would be heaven. You have all this downturn activity, you just blame it on Corona. How are we going to distinguish between the legitimate statements that these assets went down due to coronavirus, my business is gone due to coronavirus, your money's gone due to coronavirus, versus those who are using it as a smoke screen or cover? How are we actually going to decide and investigate those points?
Well, we had this issue in 2008, right? We had, to the extent that things were you're dealing with either real estate or real estate derivative value through, CDOs and other ways that value was carried out into the marketplace. We had people saying, well, there's nothing we can do. We were able to show that, no, that's all well and good, but how did you end up with a yacht and 2 airplanes and several mansions around the world as a result of that? So ultimately, you have to pierce through that chatter and that headwind, frankly, bullshit from the fraudsters, and get courts and triers of fact to see through that. We are going to see it. We saw it in 2008. There's no doubt about it that people are going to say that that value was lost, and so too bad, so sad. That's life for you folks. You just made a bad investment, and there's nothing we can do about it. And I lost money too, but we have to go behind that. And I think getting behind that is where the challenge is going to be.
It goes to your point.
And it's restorative, isn't it?
A light switch.
I'm sorry, Margo.
Right. I was just going to say, to Ed's point, I mean, that's the scenario where you're in the dark room looking for the light switch, and to Warren's point earlier, you're hoping that maybe this time with some of the changes and loosening of the obstacles to getting the information you need to dispel those defenses. Maybe you'll be handed a flashlight in the dark room to find the light switch, and you'll get there faster.
That's a good metaphor. I like that.
It is a good metaphor, and maybe I think I agree with you, and I think the initial level of activism that will produce change will obviously come from those litigants who are most desperate for a piece of information, for an unusual form of injunction or attachment. I'm heartened to see the District Court in New York issue the DTCC opinion. I mean, that's going to open up the world of securities transactions in very much the same way as the world of banking was opened up by intermediary bank discovery, arguably, and assuming it goes. Can't we say to those politicians, and Margot, in pushing this forward, to say there's actually a restorative element to this, putting money back into the economy to those who pay bills and employees and dividends instead of into the hands of fraudsters is actually something that should be of benefit to.
Hello?
Yeah.
We lost you, Warren. You're on mute. I think Warren's flicked off and come back on mute.
It's been an honor and a pleasure doing this, David. Thank you to Offshore Alert. And we certainly look forward to these future webinars. Anyone, I'll turn back to you now, David. Anyone who would like to ask a question or seek a piece of information, obviously don't hesitate to contact us. We'll be here, we'll be working. And I think the message of this is be careful, life goes on. Remember that there are people who are vulnerable to COVID and will continue to be so for 24 months. So golden rule applies. I'm sure there's all sorts of advantages that one would have for somebody being not able to attend something, but I think one of the things we discussed here is it's probably an important time for civility among professionals on this issue. Thank you.
Yeah, and to everyone who's still here, I apologize for the technical glitches. I think our platform has been infected with something itself. And I don't wish to be flippant, of course, but this is a work in progress. When it comes to frauds collapsing, I've had my eye for some time on a student accommodation fund called Coral Student Accommodation Fund at one of our conferences in London, I think maybe 3 years ago, maybe 4. I identified it as a Ponzi scheme then because its performance chart was a straight line, a diagonal line, trending upwards with little or no deviation over a long period of time, which is in and of itself 100% proof that it was a Ponzi scheme, because there's no investment in the world that you can put your money in and just get a straight diagonal line with little or no deviation. And given that, the universities have closed down, they've gone to, remote schooling, and schools generally have closed down, and you have to figure that student accommodation funds are going to be among the first frauds exposed. Because of the economic collapse, you're going to have many people seeking to redeem their investments, and there's going to be no new money coming in, and that's typically when Ponzi schemes collapse.
Hey, David, can I just make one quick point on something related to that, in the sense that students, you hit a chord with me, and that right now we have students coming out of law schools, undergrad, accounting schools, that are obviously or in school looking for clerkships, that had clerkships lined up, and a lot of that is now in jeopardy. And I think to the extent that firms can agree and understand that they may have to make accommodations, but to the extent that they can find a way to let those students continue on with their clerkships this summer and find a way to get new lawyers and new accountants and new professionals in, even though we're in this challenging environment, we have an obligation to build the next generation of professionals that are coming up. And we have to find a way to do that. It cannot be every man and woman for themselves. It's got to be a way that we do that. And there's got to be a way to do that, including just taking less money home. So I think that we've had several generations now within the last 20 years kicked in the teeth coming out of school, and like nothing else anyone's experienced. Certainly my generation really didn't experience it. And I just think that we should not forget about those young people coming out of school that are looking for opportunity, because we owe it to the profession to make sure they get a place to learn.
Yeah, I concur, and I think one of the messages that you're hearing from this panel is there's a fairly strong view that once things settle down a bit and the economic impact of what we are doing on an unprecedented scale comes home to roost, that we're going to be very busy. There's not going to be a dearth of work. There's going to be a ton of work. And one would hope, and certainly I'll try to be a part, but I hear you had too, one would hope that this sort of work will provide some hope to those coming out of school that are starting out, and to say, actually, you know what? We're very busy. Grab a shovel. There's something to do. And you know what? Some of this is pretty interesting. Do we have any questions from the audience? Sorry, David. If there are any questions from those in the audience that they'd like to see answered, I think I'm in the public chat room, but please don't hesitate. We can wait a couple minutes, but otherwise, then I think.
Do you think that some jurisdictions are just going to be overwhelmed and maybe cease to be meaningful jurisdictions when it comes to high-value cross-border finance?
What do you mean by overwhelmed? Do you mean the ability to handle the cases in their courts, or the ability to open corporations? Because I think it could go the opposite way. I think the concern I have is that countries and jurisdictions that have made strides to come into the community of nations that don't allow fraudsters to run freely inside their systems and use their systems for improper purposes may, out of desperation, walk back some of those things and want to find a way to generate more revenue. I think it's the opposite, in the sense that I think these people will start put the for sale sign out, saying, meaning values are for sale, and we'll roll back things that otherwise after 9/11 made things more difficult for fraudsters. Now are going to make it more easier. That's one of the worries I have, is that when you're starving, you're going to steal the loaf of bread. And if you think you're starving, or you might starve, you're going to steal the loaf of bread. And so the question is, what can we do to help those governments hold the line and not walk back the changes that have already been hard fought for, and then move forward into even greater changes for the benefit of transparency? That's my worry. It's I guess maybe it's the same. Maybe it's just saying it a different way.
Ed, I think I share David's concern in one respect. I think that what we've seen is a return to locality, a return to state governance, to local governance, and the importance of those regimes. I have concerns that for political or business reasons that have nothing to do with what we in this community do, which is unrooting fraud, but I have some concerns that judicial decisions, there may be a fallback to territoriality. There may be some countries, some judicial systems that decide that what is decided in England or Japan or Korea is not right for Italy, and there may be we may find some frustration trying to enforce orders from one jurisdiction to another if we're not careful. Because right now, I do think we're in a sort of every jurisdiction or every country for itself mode, and I have concerns that that could continue. What do you think about that?
I think that's probably right, Warren. I think I actually trying to think of all the variables that are changing for different countries, and to David's point of, are some of them, is this going to cause a shift? I think absolutely, but where that shift, is it focused on offshore? Not necessarily. It could be some onshore centers that find themselves, depending on how your economy's thriving, what other factors are influencing, whether it's finance, whether it's tourism, whether it's oil and gas. I think you're going to see jurisdictions struggle with some really big problems across a number of, whether it's governmental level, whether it's their whole economy, whether it's only sectors of their economy, and then what that means they're going to do or how they're going to react in some to litigation or to enforcement proceedings or to requests for information. I mean, it's difficult to say how that's going to play out.
I think we're saying the same thing in the sense that because of these huge problems, some of which aren't even COVID related, the oil and gas issue is exacerbated by COVID-19, but it's not caused by it. People are going to walk back changes. They're going to be susceptible to people coming to them saying, "Hey, I know a way out of this for you. And you just have to, let us use your government, use your legal system, use your corporate registration system to generate revenue." And they may fall for it. That's all I'm saying, is that it's an opportunity for fraudsters like Alan Stanford, for example, who essentially captured the government of Antigua and Barbuda for a while. Are you going to have more Alan Stanfords out there that are going to capture jurisdictions and lead them, either to the dark side or back to the dark side? That's what I was trying to say inartfully, but I think we're all kind of saying the same thing.
Well, a lot of offshore centers, they have two pillars to their economy, financial services and tourism. And clearly tourism has collapsed, right? And, they employ a lot of people, they contribute tax dollars, tax dollars fund courts, fund, various services, etc. So that's why I would have some concerns for some of the smaller major financial centers.
I mean, you literally are talking about a flood of complaints or a flood of insolvency filings that is so big that the court system couldn't handle it?
Well, I think you'll have on the one hand, you'll have a flood of insolvencies, and on the other hand, you'll have a lack of funds to, because of the collapse of tourism, for example, to fund, more judges or just existing judges, to fund just general services.
That's fair. That's a fair point. That's a fair concern and a fair worry, I think, that those things in the short term. But again, to the extent that old systems, which are not geared toward rehabilitation or not geared toward clearing the garbage out of the way and letting, moving the cases quickly through the system like our insolvency system does in the United States, which there's a lot of criticisms, but one thing it does do is it moves fast. To the extent that insolvency systems, to my way of thinking, can be criticized worldwide, is they're too slow. They're just too slow. You have a patient dying, and you have the doctor sitting in the break room eating a cheese sandwich rather than getting into the operating room. That's the problem, to my way of thinking. And you need to get these doctors into the operating room, and to use the metaphor, and perhaps insensitively, and that's not happening. Because of underfunding, because of an archaic system, because of corruption or soft corruption or all of the above, you have systems that simply don't work. And if you don't get them to work in this environment, you are going to be facing a world of hurt.
Well, I had one question, which we didn't have time to really address in the panel, but it's something that has been bothering me. So this is for Ed and Margot. We operate in a world, as Ed was just saying, patients dying. You need to get in there, get a seizure, get an injunction, or you're never going to see a piece of asset or property again. At the same time, we're living now in a world of genuine emergency. in a world where the emergency is health oriented and whatever you're doing, it's just about money. Some courts, at least in the US and in some others, have really smacked professionals contending X, Y, or Z as an emergency or emergency filing, seeking a TRO, when that's frankly what we used to do before. Do you think that the definition of emergency or courts' willingness to enter TROs, injunctions, Mareva orders, what have you, will be impacted by the very serious circumstances presented by this crisis?
Good. I think that's a really good question. I think that you have to be careful now, pre-COVID, when you use the word emergency or the word urgent, because lest you be crying wolf, and you better be able to substantiate the emergency. I think it's going to be harder to be heard with that word, because the judge could easily look at you and say, really? You think that's an emergency? With people dying all around us. So I think that you're right on the money with that question, Warren, that I think it's going to be harder to be heard. And so we're going to have to be much more diligent in creating the underlying factual predicate to substantiate urgency and an emergency. And we got to be careful not to overuse it, lest judges not take us seriously when we really have an emergency. I think that's right, Ed. I think that's exactly right. That it's a bigger hurdle than it once was, and you better be clear. You've got a clear emergency if that's what you're going to the court with. I think some courts have made it easier in terms of just highlighting that they just won't deal with those kinds of applications. They're not interested. And others have been more, I suppose, on a case by case, flexible. Let's see what the facts are and then decide. So. Yep.
Okay, well, thanks very much. I apologize again for the technical glitches. We will be holding webinars every week, at least one a week, sometimes more. The schedule will be available at offshorealert.com, our website. If you go there, you'll see what we have lined up. Thanks, Margot, Ed, and Warren. And I'll be in touch. Thank you.
Thanks. Thank you. And thank you for covering for us, Warren, while we were scrambling to get back on. We appreciate it.
Thanks to everyone who persevered through this, to all the attendees around the world. Thank you.
Bye.
Well, that's done.
Hey, are you still there, Warren?